Your Lordship, may I mention one matter regarding a civil revisional application that has been assigned before your Lordship. I'm praying for inclusion in your Lordship's list.
Civil revisional application, assigned matter.
Yes, your Lordship.
You are for the petitioner.
I'm for the petitioner, your Lordship. I've also served upon the opposite party as well. I've annexed the receipt copy of.
You are for the.
Mine other matters.
Okay, okay. Yes.
This also, my lord, assigned before your lordship or a similar matters, your lordship. There's no caveats being filed. So,
How many matters?
in fact, 3 matters, and the other 2 matters arose from other orders, which could not be heard out. So it was pending. So all the 5 matters it was released by his lordship due to personal ground.
What is the matter involved?
My lord, we have challenged the entire execution proceeding. But the execution proceeding was the executing court is proceeding, my lord, contrary to the judgment and decree that being passed by the Honorable Supreme Court. In a decree for under section 13(1)(f), my lord, they are the court to proceed, the parties to proceed under the provisions of section 18A of the old Act, Old Tenancy Act, your lordship. My lord, wherein, my lord, the judgment debtor defendant was to avail the provisions of before the rent controller for executions of the decree, for getting over the possession. It's specifically stated in the provision also, as well as the Honorable Supreme Court also.
Decree of small causes court.
No, decree, my lord, decree passed by the Honorable Supreme Court.
Okay.
And father directed the trial court to pass a formal decree. And at that point of time, my lord, the trial court being the city court passed the decree. Subsequently, my lord, we had to put the decree in execution as per section 18A before the executing court being my executing court being
You are the decree holder or
small-
judgment debtor?
Yes.
You are the decree holder.
Initially, we are the decree holder. We obtained the possession, your lordship. We obtained the decree on the ground of rebuilding. Building almost constructed, your lordship. There's a direction for handing over possession to the tenant by the decree holder. So at present, your lordship, the tenant are the decree holder. We are the judgment
Tenant
debtor.
or the decree holder?
At present.
Okay.
At present, the tenants are the decree holder for getting back the possession.
Okay, getting back.
Yes,
the
your lordship.
in terms of the
My lord, Tuesday, that date has been fixed, your lordship, for police cell in 3 of the matters. My lord, so it would be Monday.
Monday, it is not possible. Monday, 21. Monday, 21, it cannot be.
My lord, it's very Tuesday, your lordship, the date has been fixed for police cell.
21st of July, the court proceeding would not be done. You understand the situation?
Yes, yes.
Then it would be usually appear on 22nd.
22nd. Maybe it would be taken up in the morning, your lordship. The first.
Records are checked. 2 women.
Yes. Obliged, your lordship.
Yes. Call the list.
May it please lordship,
I appear.
Yes.
Please.
I beg to appear on behalf of the petitioner. Misfortune is running behind me. Today it was
Why?
fixed. Yeah,
It was fixed 10:30. Now we are sitting 11:45.
45, and in 12 there is another matter fixed.
Okay.
Another matter
Another matter was there.
before your lordship. Your lordship has fixed a matter at 12 p.m.
Today, 12:30.
No, that's 12:30, my lord.
12:30 matter.
Sir, it is 12:30.
12:30.
I can proceed now.
Yes, you can
May I-
proceed.
Lord, I had the privilege to place this matter on an earlier occasion. Beg to remind your lordship the basic facts of this case.
Yes.
There is a hotel known as Fabworth.
We had filed a short note, my lord, on the last occasion.
I'm going to make it shorter.
Let a copy be given to me also so that I can track.
What? What
No,
copy you want?
No, not an
Yes, yes, it will be immediately handed over to you.
Short notes of argument, short notes of date.
List of dates or whatever document
List of date. You know the list of dates. Yes, got it.
we given it.
Please proceed. Yes.
My lord, there is a hotel known as Badger's Hotel. Kindly excuse me for a moment. This is Badger's Hotel
Yes.
on the northern side of ITC Sonar Bangla. ITC Sonar. The plot of land belongs to KMD.
Okay.
KMDA invited tender for the construction of a hotel. My client Fabwat participated. They were the most successful bidder and they were granted a lease for 99 years and a renewal period of another 99 years. Lease was granted, but the lease was granted for a specific purpose. The purpose was I am to construct a 5-star or 7-star hotel there with all attendant facilities. I can't do anything else. I have to construct a hotel 5-star or 7-star according to municipal plan and with all attendant facilities in a 5-star hotel. I constructed after getting sanction from the municipal corporation. No difficulty. Sanction, along with sanction fee, another amount of more than 3 crores was collected from me. Why this was described as development? My client was in a hurry to construct the hotel, paid the development fee of more than 3 crores. In my notes, that is in.
Yes.
There was usual sanction fee. Kindly remember, my lord, I am a lessee. I am not entitled to do anything else on this leasehold except construction of the hotel. Who directed me? The lessor. KMDA said you are to construct a hotel. Therefore, development is being done by me according to instruction of KMDA. They are the owners. They leased out the plot to me for the construction of the hotel. One question is there: who is developing? KMDA through me. I am doing it independently. If I take a bare plot of land, and either a hotel or a residential building, I have no option. I have to construct only a hotel.
Yes.
Did it. And at the time of paying the sanction fee, they collected from me a development. I paid the development fee, my lord, without being able to ascertain the true character of the levy. Thereafter, my lord, I completed the building according to the plan. After completion, I wanted to take a completion certificate. They demanded another 3 crore as development fee. But I objected and wanted to know the authority for the levy and collection of this fee. Dispute cropped up, and in order to get the completion certificate, I furnished a bank guarantee. They accepted the bank guarantee and issued the development and the completion certificate. And I moved this honorable court. This honorable court directed them to disclose the legal and factual basis for the imposition of development. You will kindly turn to one act. The act is Town and Country Plan Act 1979. My friends there, will you kindly hand over? Town and Country Planning Act, kindly hand over one copy. Mr. Mitro, is there a copy with you?
West Bengal Town and Country Planning Development Act, 1979.
1979. Kindly turn below. I'm not going to trouble your lordship with other sections. Section 102.
Yes, 102.
Levy of development charge.
Yes,
In accordance with the provisions of this Act and the rules made thereunder, and with the previous sanction of the state government, every planning authority or development authority, I am a lessee under KMDA, which is a developing authority, shall by notification levy a charge herein called the development charge on the carrying out of any development or change of use of land for which permission is required under clause under chapter 7 in the whole or any part of the planning area at rates not exceeding those notified under section 103, provided that the rates may be different to different parts of the planning area. Now, my lord, kindly turn to subsection 3.
yes,
Notwithstanding anything contained in subsection 1 and 2, no development charge shall be levied on development or change of user of any land vested in or the control and possession of the central government, state government, or any local authority. Therefore, no
KMD is the local authority.
KMD is a local authority. There is a decision I'm giving your lordship. The decision is 77 Calcutta. AIR 77 Calcutta. Kindly have a look at that authority, my lord, the division bench judgment.
Yes,
Kindly, my lord. Paragraph 8.
paragraph 8.
Kindly have a look at that paragraph.
Yes,
State have held to be a local authority. last 5 lines. Last 5 lines
Yes.
of paragraph 8.
CMD is therefore statutory authority which is power within the specified area of development.
The last 5 or 6. Patient about.
Yes.
So there is no dispute that KMDA is a local authority. Now, my lord, kindly turn to section 102, subsection 3. Page 49, 53 Bombay.
Yes.
May I read out subsection 3 once more? Section 102. Notwithstanding anything contained in subsection 1 and 2, no development charge shall be levied on development or change of user of any land vested in or under the control and possession.
Yes.
Expression important is vested. In our case, in whom the land is vested, the lessee or the lessor. The lessor is the KMDA. I am the lessee.
Yes.
My lord, this question has been decided in a case involving this Fabworth, the petitioner before Lordship. That's reported in kindly hand over the judgment. A judgment of the division bench reported in 2016 Calcutta Law Times. 2016 Volume 3 Calcutta Law Times 509. Has it been handed over to your lordship?
Yes. Got it.
My lord, here the question was property tax on whom to be levied, the lessee or the lessor. The division bench held in a case involving my client and the KMC, the Kolkata Municipal Corporation, that the levy is to be made on KMDA, not on the lessee, because the KMDA is still the owner. If he is the owner in whom the land is vested, if the KMDA is the owner in whom the land is vested, in my respectful submission, the KMDA.
Yes.
Owner, in technical language, it is said that the reversion is vested.
Okay.
There are two. This is a case in which Fabworth, the petitioner before Lordship, was involved. Matter between Fabworth and KMC. I am giving the Lordship a lot two other judgments. The first judgment of Justice P. N. Mukherjee One of the renowned judges of the Calcutta High Court. ILR 1968. To Calcutta. ILR 1968. বইটা আছে? Explain to your lordship. Your lordship has dealt with, my lord, cases under the Premises Tenancy Act.
Yes.
One type of suit is suit for eviction on the ground of own use and occupation. The landlord wants it for its own use and occupation. In the Premises Tenancy Act was the provision he can sue on the ground of own use and occupation if he is the owner.
Yes.
Now, my lord, a lessee couldn't sue on the ground of own use and occupation. A permanent lessee also cannot sue because he is not the owner. The reversion is not vested in him. The land is not vested in him. Justice P.N. Mukherjee, my lord, in this case, short judgment, kindly have a look at the expression owner and permanent lease are not synonymous. Note. The word owner must be given its ordinary connotation or dictionary or usual meaning. That is a meaning having full and absolute ownership.
Yes.
I'm a lessee for 99 plus 99 years renewal, in whom the land is vested, not in me. The reversion is vested in KMG. Why reversion? Suppose I become, my lord, I am liquidated. My company is liquidated. The property will go back to KMD because the reversion is
Yes.
vested in KMD. This is I'm not going to read it, my lord, it's a very simple judgment. A permanent, even in the case of a permanent lessee, he is not the owner. The ownership is vested in the lessor. Permanent lessee. That is also 77.
Yes.
Well, the other judgment I beg to rely upon is a judgment of the Honorable Single Judge Justice Murari Mohan Datta.
$77 CWN.
Yes, 77 CWN 424. Large number of judgments were considered. One of my late lamented friends, Sudhish Rajgupta, was appearing for the respondent against Mr. Prafulla Kumar Roy, a very senior advocate. And the question was, in a long-term lease, who is the owner? He's virtually having the control over the property for a long time.
Yes.
He's the owner. That is, Doctor. Kindly have a look at the judgment below. I'm not going to read the whole of it. In the case of persons having unequal rights in a thing, the person whose rights are indeterminate and residuary, lessor has the residuary right. Why residuary? After expiry of the lease, the property will revert back to him.
Yes.
Lessor is the residuary owner. After the expiry of the lease, the property will. The person whose rights are indeterminate and residuary is the owner of the thing and not the other person who have such rights or have only lesser right. Lessee is not the owner of the property. is not the owner within the meaning of the act. The suit at the instance of the lessee for the eviction of a tenant. That was also a suit for eviction under the Premises Residency Act. The honorable judge held the lessee is not the owner, he cannot sue, even a permanent lessee. Now kindly apply these principles laid down in this judgment. Who is the owner in my case? KMD. In whom the property is vested?
KMD.
KMD. Section 102, subsection 3 says, kindly read subsection 3 once more.
Yes.
Notwithstanding anything contained in subsections 1 and 2, no development charge shall be levied on development or change of user. I am being subjected to development charge on development or change of use of any land. And what is exempted? Not the developer, but the land which is being developed. What is exempted is not the developer. He is not given the exemption, but the land which is developed. Subsection 3, Milord, can you?
Yes.
Notwithstanding anything contained in subsection 1 and 2, no development charge shall be levied on development or change of user of any land vested in or under the control or possession of the central government, state government, or any local authority.
Yes.
Justice Murari Mohan Dotto in 77 Calcutta Weekly Notes. No, I'm sorry. 77 Calcutta. 77 Calcutta. 437. The judgment is before Lordship. Paragraph 8, last 5 lines.
CW.
No, 77 Calcutta.
Oh, अच्छा. हाँ, ये आगे था. हाँ.
No ambiguity. Paragraph 8. Justice Dotto is holding Calcutta Metropolitan Development Authority is a local authority in the meaning of the General Clauses. A land which is vested in the local authority
Yes.
Section 102, subsection 3. Land vested in the local authority is exempted. Not the owner is exempted. Not the developer is exempted. The land is exempted. What is the significance of this submission? What is the significance of this submission? When the land is leased out, the land enjoys the immunity because the land is exempted, whether it is in the hand of the owner or in the hand of the lessee and sub-lessee. Am I clear to Lordship?
Yes.
What is exempted? The land. It may be in the hands of the owner, it may be in the hands of the lessee, or in the hands of the sub-lessee. Because I can give you a Lordship analogy. In the Premises Residency Act, certain exemptions were granted. One of the exemptions was the land owned by the state government is exempted.
Yes.
Now, the state government is granting a lease to me. I am granting a lease to another person. Now the sublease between me and another person enjoys the exemption because it's in respect of the land. What is exempted is the land, whether it is handled by owner, lessee or sublessee. Now this question was considered with the Supreme Court in 1953 Supreme Court, page 16. সুরজিৎ আছে বইটা
1953 Supreme Court.
1953 Supreme Court, page 16.
Yeah, yeah.
Yeah. Now in the Bombay case, the question was similar exemption in the Bombay Act, Bombay Premises Tenancy Act. If the land is subleased, does the exemption prevails? Kindly turn below to paragraph 9. Paragraph 9,
Yes.
last 5 lines. Kindly read these last 5 or 6 lines of paragraph 9. The relationship is not exempted. The land is exempted.
No, this is 1952. SC
53.
It's your-
53.
It is 50.
The same judgment has been given to your lordship. The same judgment has been given to your lordship, reported not in AIR.
That is not matching.
Huh? Bhatia, same judgment. Bhatia,
Bhatia Cooperative Society.
yes. The same judgment, but kindly turn to paragraph 9.
Paragraph 9. Yes.
Act.
Paragraph 9.
স্যার একটু প্যারাগ্রাফ 9 এর শুরুটা বলবেন, এই কপির সঙ্গে মিলছে না এখানে।
This act shall apply. This act shall apply.
এক মিনিট স্যার,
Last
Meet
line.
maybe.
Yes, some other.
না না এইটাই।
Paragraph 9.
স্যার প্যারাগ্রাফটা কি দি মেইন কন্ট্রোভার্সি শুরু?
No. This act shall apply in respect of premises belong to the government or local authority.
Paragraph 11.
11, yes.
Now kindly come below to the concluding part of that paragraph. The legislature was familiar. Concluding part of that paragraph.
The legislature was familiar with this
Yes,
form. This is paragraph 13.
Yes.
Yes, got it.
I'm sorry, Mirror, I'm reading from AIR.
No, I understand.
The legislature was familiar with this form of expression, for it adopted the second, and for it is
Second part.
adopted within the second part, the new Yet it did not use that form in the first part. The conclusion is therefore irresistible that the legislature did not, by the first part, intend to permit the relationship of landlord and tenant, but intended to confer on the premises kindly read these few lines over and over again. There is a relationship of landlord and tenant. The legislature didn't exempt the relationship, exempted the land. And if it is exempted, it is available at all stages, at the owner stage, at the stage of lessee, sub-lessee. Now in our case, the legislature exempted the land. The land is not subject to any development charge, whether it is the hand of the owner, the lessee or the sub-lessee. The land enjoys the immunity. Same thing will not in here, familiar expression. In subsection 3 of section 102, what is provided? Shall be levied on the development or change of use of any land vested in. What is exempted? Not the construction, not the development. On the land.
Yes.
Land may be in the hands of the owner, land may be in the hands of the lessee, land may be in the hands of sub-lessee. Just as in Bombay case, Bombay Supreme Court saying what is exempted is not the relationship. What is exempted is the land, the premises.
Yes.
The legislature has not provided development where the owner is exempted. Legislature has said development of the land is exempted. It may be by the owner, maybe with the lessee, maybe with sub-lessee. The exemption, the immunity is enjoyed by the land. This land, if developed, is not subject to development charges. That is subsection 3. If this land is developed, now in my case, admitted I am the lessee. Lessee for 99 plus 99 years. KMDA has granted me lease for construction of a hotel. After expiry of the hotel, I am bound to sell it to KMDA. KMDA is now imposing a development fee on this land. I am saying I am not developing. I am merely carrying out the command of the KMDA. KMDA wanted this plot to be developed as a hotel. It's the command of the KMDA. And you were charging me a development fee for that purpose. That is the first point.
Yes.
Second point, leave aside all controversy. Is the land exempted? Is the land enjoys an immunity? And how can he impose? That's the command of section 102, subsection 3. Now, my lord.
Yes, I understand.
Look, there is one golden principle. In this Honorable High Court, a case was argued for 7 or 8 days. A drainage development fee was imposed by the Calcutta Municipal Corporation. We want to construct a house. Apart from sanctioning fee of the plan, I would have to pay a drainage development fee. They would develop the drainage system. The question was whether it is legal or not. That point was argued before a division bench, presided over by Mr. Bhaskar.
Okay.
And it was argued, Justice Bhaskar,
Yes.
Dr. Chand. The matter was argued. Kindly, my Lord, have a look at that judgment. No, that's not right. It is reported in 2007, 3 CHN 476. The point argued before the division bench was drainage development fee.
Yes.
Calcutta Kolkata Municipal Corporation provided for drainage development fee by making rules under Section 131 of the KMC Act. KMC Act Section 131 provided with the preparation of budget. In the budget estimate, Kolkata Municipal Corporation included drainage development.
Okay.
Argued before the High Court. In the budget estimate, you are including drainage development. Where is your power to impose it? Why this question of power? It is a statutory authority and it acts under the statute. Kindly recall me, Lord, the language of Section 1, Article 265 of the Constitution.
Yes.
Is a copy of the Constitution available before our chief?
Yes.
Two 65.
$265.
265.
Yes. No tax shall be levied or collected except authority of law.
Under the authority of law.
Yes.
What law? Law means what? Your departmental rule. The division bench shall know it is a legislation made law. The legislation made law must provide you, empower you to levy the development fee, drainage development fee. Otherwise, the imposition is ultra vires. Refund amount. I'll take your lordship because it was argued for 7 days and the Supreme Court has approved it not merely by dismissing the SLP, but by saying that nothing wrong with the judgment. Kindly turn me, Lord, 2 or 3 paragraphs, my Lord.
Yes.
Kindly turn to paragraph 12. Kindly remember this principle. May I read out? I am very fond of this principle. At this juncture, it will be profitable. Just before paragraph 12, In paragraph 11, the article 265 has been quoted.
Yes.
Paragraph 11, 265 has been quoted. Para 11.
Yes.
Then paragraph 12. At this juncture, it is profitable to refer to the well-known proposition of law that a natural person has the capacity to do all lawful things unless his capacity has been curtailed by some rule of law. It is equally a fundamental principle that in the case of a statutory corporation, it is just the other way. The corporation has no power to do anything unless the powers are conferred by the statute which creates it.
Yes.
The statutory corporation must be empowered. A natural person is only to be forbidden. If I'm a natural person, unless forbidden, I can do anything else.
Yes.
But a corporation cannot do anything unless empowered. Now, my lord, section 102, subsection 3 says that no development which shall be levied on a plot of land vested. How do you do it? Yellow. Hey, Suraj.
কিছু হয় না।
Yes. Please proceed, sir.
Hasn't got it, my lord. My lord, kindly look at that in paragraph 13. Supreme Court judgment. কিছু বলছো? এই
না, স্যার।
সুরজিৎ,
আমি একটুখানি আসছি।
ও আসছো তুমি? এসো, এসো। Paragraph 13, my lord.
Yes.
In the subjoined case of Ahmedabad, just a second.
Ahmedabad Urban Development Authority. It appears to us.
Ahmedabad Urban Development Authority reported in 1992 Supreme Court. The Supreme Court made the following observation.
Yes.
It appears to us that in a fiscal matter, it will not be proper to hold, even in the absence of express provision, a delegated authority can impose tax or fee. In our view, such power imposition of tax or fee by the delegated authority must be very specific, and there is no scope of implied authority or imposition of any such tax or fee. It appears to us the delegated authority must act strictly with the parameters of the authority delegated to it. Under the Act, it will not be proper to bring the theory of implied intent or the concept of incidental or ancillary power in the matter of exercise of fiscal power. There also, my lord, an imposition of a fee by municipal authority, development authority, was under consideration. And the Supreme Court held you can't do it unless Act specific authorizes it. Now, in this case, after long discussion, my lord, kindly look at the concluding part of it. Everything was directed to be repaid, refunded. Look at the last paragraph.
Yes.
Development fee was collected.
refund the development fees collected from the writ petitioners.
Not one writ petitioner, my lord, there were about 13 or 14.
Yes.
Refund to everybody. Matter went to Supreme Court. And the Supreme Court heard the matter at length and said there is no merit in the appeal. Dismiss. This is not dismissal of the SLP. Not the dismissal of the SLP. On merit said no merit in this.
Okay.
Therefore, this was approved by the Supreme Court. Now, my lord, I have tried to complete within 12:30.
Okay.
My lord, in reply, I have given the broad indications of my argument. Broad. I have not read the judgment. I have read the head note, not proper. But I had to conclude before 12:30. I didn't want to make part submission. Now, after my learned makes the reply, given the reply, I, in my turn, might add something here and there.
Okay. For KMDA. So I have a matter fixed on 12:30 today. So when you can,
My lord, in that event, if your lordship kindly takes up after 25th, any date if my learned senior friend, subject to convenience of my learned.
31st of July.
31st.
Just wait.
I give it.
31st of July, 12:30.
All right. Get to your lordship.
July.
I'm praying merely, my lord, that I have merely read out the head notes. I wanted to expedite it. If necessary, I will take your lordship to the body of the judge.
Okay. In reply, you can.
Yes.
My lord will be fixing at 12:30.
12:30. What do you want?
My lord, I may require some time. Not finished on that day, another day. Very well.
Yes.
Subject to a question.
Let it appear on 12:30. You start the matter on that. Okay. Argument on behalf of the petitioner concludes.
My lord, my learned friend has difficulty on Thursday.
Thursday, my lord, on Wednesday.
Generally, I took up the land matters on Thursday and Friday.
Thursday and Friday it is taken up. Then 1st August. Then
And
1st.
Friday also. Which can be fast on fast.
First.
Yes, madam.
1st of August.
1st of August.
Very well, no issue. Just wait. 1st of August. Akash. 1st of August, 10:30.
10:30.
As
No
you
problem.
lordship. As you
It will be proper.
As you lordship.
Very good. Argument on behalf of
It's
the
a difficult task for me to counter my learned senior.
Very good. Thank you, madam. Let the matter appear in the list on 1st of August 2025 at 10:30 as a specially fixed matter for argument on behalf of the KMD respondent.
Grateful lordship.
Thank you. আলাদা করে ফাইলে রাখবেন, এর সঙ্গে আলাদা ফাইল করে পিছন দিকে রেখে দেবেন, এটাও রাখবেন।
পড়ে গেছে তোমার।
Call the 12:30 matter.
Lord, this matter, my lord, I'm appearing on behalf of HITCO, my lord. Lord, maybe come back on Monday, my lord. Lord, Mr. Mujumdar is leading me, my lord. He is on his days in court number 26, my lord.
Monday this matter cannot be taken up. You know the system. I can only take up these matters on petitioner matter.
My lord, then, my lord, next week, my lord, subject to your lordship's convenience, my lord. Lord, I'm for the petitions, my lord. Very time. No, time look কখন ধরবে আজকের হবে কখন?
You are for the petition
I'm for the petitioner.
and you are for the respondent.
Respondent HITCO, my lord.
State respondent,
HITCO. So
Very
petitioner
short.
has to first start fast.
very short matter.
Not only for this day, my lord, I am praying for an adjournment.
So this matter can be concluded this day. That's why I fixed the matter to 12:30.
Yes, ma'am. Last week also,
Not a very
The difficulty is only 2 days I am taking the matter in a week. That's why the fixing date is very difficult. It was fixed so that are good that the matter can be disposed of today.
that was fixed on the presence of both the parties.
I understand. Right now.
Then your lordships prepone the time if in place of 12:30 can be taken up 12.
দেখো তো 31 তারিখ হবে কিনা 31st 31st 12:30
31st কি বার আছে?
একটু আজকে
31st I have no objection to this.
Okay.
31st.
An accommodation is sought for on behalf of the respondent number 3 and 4.
3 and 4, my lord.
Let the matter appear in the list on 31st of July 2025 at 12:30.
Grateful, my lord.
Well, it can be preponed in place of 12:30 to 12, my lord. Otherwise, the difficulty is various. আরে আমি জানি 10 মিনিট
আমি নিজে 31st. 31st.
On that date, you start fast.
I will only 3-4 minutes.
Very good. On your submission, I fix the matter today specifically so that the matter can be disposed of. But however, maybe let it appear on 31st. I will dispose of that date.
Highly obliged.
Call the list.
This is my matter, my lord.
My lord, your lordship will take up this matter, my lord, for hearing, my lord.
Why it is appearing under extension of interim order?
My lord.
My
My lord, the last.
Interim order is there.
Yes.
Yeah. My lord, there is an
My lord.
encroachment over the PWD land. The petitioners are encroachers. 10-3 notice was given. They preferred appeal. Now they have come before this one.
No.
Interim order.
I have not prepared appeal, my lord. I have challenged the, my lord, order on the basis of jurisdiction, my lord, as per section 5.
For that,
My lord, this matter was heard, my lord, since 2022, my lord. Since then, my lord, the interim order was passed because, my lord, the state was directed to file, my lord, one report, my lord, regarding section 5 of West Bengal Highways Act, and that was not filed till the date, my lord. That's why, my lord, the matter is, my lord, pending, and the matter is
there, I
fixed.
think.
Yes, my lord.
Statement of facts is placed.
Yes.
Statement of fact is there.
Yes.
So what you want? What reply you want?
My lord, the gazette notification that was required in this particular matter, my lord.
Gazette notification.
Gazette notification as per section 5.
Lord, this land is not under the
And my lord,
PWD. There is no
the
gazette
interim
notification
order,
under section 2.5.
my lord,
But
your
this
lordship
is
fix any
encroacher,
date, my lord, I will satisfy to your lordship. Because my matter is fixed under heading hearing, my lord, and the interim order was lastly extended on March 10, 2025, my lord.
What you want? Gazette notification.
Gazette notification, my
Gazette
lord.
notification is here also.
No, that
No,
is
no,
not the
that is
gazette
not the
notification.
Gazette notification to the effect that land belongs to the PWD department
No,
and
no,
who is
no.
the authority?
No. Land
Well,
belongs to the, my lord, the authorities kindly see the, my lord,
This is
section 5.
encroacher. It is
Appointment.
right to say so.
Uh,
It's a PWD
But
government
I
land.
will satisfy to your lordship.
What
fixed
is
any
your
date.
case?
My case is that, my lord, the petitioner, my lord, when an order was passed under section 10, my lord, by an authority.
Well, let
who
him
is
show
not-
the documents whether he
No,
belongs
my
to
lord,
the
that
land
is
in
not
question.
hearing, my lord, fixed any date, my lord.
Any document, my lord.
One-
Before your lordship. That he
Tuesday,
is
my
the
lord,
owner of the land. in question.
I will satisfy to your lordship. And that I have already satisfied
Why you are not
before
coming?
before this.
The report is there.
Yes,
The report is also placed.
I have placed, my lord, reply to that extent, my lord.
argument was also heard, judgment law placed.
Yes,
What is your prayer in the
my
writ petition?
prayer, kindly see my lord the writ petition then.
What is your prayer?
My lord, kindly see my lord page 30. And I have participated in the my lord proceedings. And I, my lord, asked for two reports, my lord, whether the land was declared under section 3 of West Bengal Highways Act or not. And my lord, further, my lord, whether the authority who passed the order was appointed under section 5 of the Highways Act or not. Now, my lord, kindly see section 5, just for once.
No, you are the occupier over the land.
I am the occupier over the land.
How you are occupying there?
My lord,
Is there any?
yes,
You have
there
the-
is no permission.
Have you purchased the land?
No. I am the occupier of the land as the, my lord, the.
How you got the possession?
No, I am, my lord, without taking my lord permission from the authority, my lord, I am sitting over the land by making one garage. That is admitted. I have admitted in the writ petition.
You
Also.
pleaded there in the writ
Yes,
petition.
I have pleaded there.
That means you are the forceful occupier of the land.
I am the I am the occupier on the land. Allegation, super the allegation, one writ petition was moved. My lord, the direction was passed.
No.
Hearing was done. I said, my lord, the authority who was conducting the hearing, my lord, have the power to conduct the hearing or not. That is my respect to submission before the authority and my lord, the
That means STO.
High Court. And my lord, the High Court directed to submit gazette notification. I have, my lord, given reply to that extent that what is the, my lord, gazette notification. As per the act and at my lord, the Kolkata gazette notification, I have annexed in the, my lord, reply to that extent. My lord, so far this section 5 is concerned, my lord, your lordship kindly see, my lord, there is a judgment order passed by Honorable Justice Subra Ghosh that, my lord, said that you please file a report annexing the gazette notification. Well, till the date, no gazette notification has been submitted. And that is the requirement of
another
the,
date, Milord. I shall produce all the
That's it.
documents regarding the documents, Milord.
Very
Date
well.
agreement and others.
Very well, my lord.
Short date be given, Milord.
Very well, ma'am. Till the date, my lord. kindly-
Similar circumstances, they moved another writ
Very
petition before the Honorable Justice Amrita Sinha. That is dismissed. Preferred appeal before the Honorable Chief Justice.
My lord, I
That
have
has
not,
also been
my
dismissed.
lord, I have not preferred any
The
application.
তোমাদের case similar circumstance, another writ petition. আমি তো বলছি।
Very good.
That should be clear.
So today it is appearing under the heading extension of interim order.
Yes.
আমরা আর ওগুলো দেখতে
24 তারিখে কি আছে?
গেজেট নোটিফিকেশন মেলার তো করে দিন
24 তারিখ 10:30 আছে।
জজমেন্টাল এতদিন দিইনি আমাদের
দুটো করে ছেড়ে
পাইনি
দাও,
তো এই
দুটো কথা ছেড়ে দাও।
এতদিন কালেকশন
2022
করছি
থেকে এখন পর্যন্ত
25 তারিখ।
my lord, it is appearing, my lord, under the if the report and reply have been exchanged.
Within 25th, is it possible
My lord,
to submit all reports as
Time
required by this court?
till the time, my lord, my interim order may be extended.
That
Fix any date, my lord. I have no objection.
25th, 10:30.
Yes, 10 minutes right at 12:30.
12:30 I have a fixed matter.
Another 12:30 another day tomorrow.
Okay. Then 31st,
That to us.
31st 12:30.
31st. Yes, Milord.
31st 12:30. Very good. Please take down this matter appear under the heading extension of interim order. Now appear under the heading to be mentioned. Learned counsel for the petitioner submits that this court has passed an interim order which was extended time to time. He prayed for extension of that order. Also, learned counsel for the state raised strong objection and submits that the matter is otherwise ready for hearing. Let the matter be fixed for hearing in a particular date. Considering the submissions, considering the submissions of the parties, and after previewing the record and papers, it appears that the pleadings have completed. So the matter may be fixed for hearing. List the matter on 31st of July 2025 at 12:30 under heading hearing as a specially fixed matter. Full stop. Next para, interim order passed by this court on the lastly on 30th of June 2025 be further extended till 8th of August 2025 or until further order, whichever is earlier. The state authority is directed to place all the documents, reports as directed by this court on the earlier, on the adjourned date. Call next matter.
Item number 4, Lord, I beg to appear on behalf of the petitioner that on last occasion, Lord, there was a direction upon me to use exception towards their report, along with KMC has taken an altogether different stand from the previous occasions. So to bring that on record, Lord, my client is suffering from viral fever, Lord, kindly Lord, make it just only not today. I can do it on the next
Thursday.
second.
Next Thursday.
Next Thursday. Kindly make it at top. Otherwise, games.
Next Thursday.
State
Next
can
Thursday
able to-
under the same heading. That means it will appear first half. Please take
And
the,
again, KMC is not appearing. The answering respondent is the KMC, not the state.
okay.
On several occasions, we have served them.
What can be done? Let me proceed accordingly.
Malab.
Learned counsel for the petitioner seeks accommodation for submission of reply against the supplementary affidavit filed by the respondent number
Against the
5
report,
and 6.
against the report, exception.
Against the report filed by the respondent
KMC
number
have
5
done.
and 6. 5 and 6. You are 5 and 6.
KMC, yes, 5 and 6 minute KMC.
কি বললাম?
Exception কিছু দিলে? আচ্ছা ঠিক আছে। কিছু দিলে? ঠিক আছে।
Against the supplementary affidavit.
But
not-
I am led by Mr. Alok Ghosh, minute.
Okay. The submission of reply against supplementary affidavit filed by respondent number 5 and 6. Full stop. Let the matter be adjourned to list the matter under the same heading on 24th of July 2025.
কত নেক্সট আছে তাই 24 তারিখ হ্যাঁ গেটফুল চলে আসছে
দাদা
নেই, আমি তো বলবো। না।
আপনি বলুন আমি কেন Call next matter.
Item number 5, I am for the respondent.
I'm paying a 1 day accommodation. Mr. Somen Datta leading me his MB code number 37. That is going on.
What is the application?
For restoration.
Application for restitution.
Application for restoration, after 5 years.
As stated, why the delay has been made? On that file, that time, over to mention the actual date. Actual date.
Dismissed for default in the year 2020. March 12, 2020.
Fact remains that an advocate of the petitioner expired. He had informed. He was Abhijit Bandyopadhyay was the leader. Advocate record. Next, we contact withdrawer. Next, Abhijit Bandyopadhyay also expired. Therefore, I collected the certified copy of the petition from the office department. Therefore, he came to know.
Very reluctant petitioner.
Yes.
1992
1992 writ petition.
petition appeared in the year 2004, thereafter 2020, and dismissed. Very well. Come on Thursday, next Thursday, not this week. Now, Likhana. On the prayer of the learned counsel for the petition of the matter be adjourned today. List the matter on 24th under the same heading.
Objection there.
But I am for the Chandanagar Municipal Corporation.
Lordship, this writ petition relating to Lordship the encroachment of the petitioner's land, that utilizing the petitioner's land, the done which is to the municipality, sorry, Chandanagar Corporation, Lordship constructed a bridge without acquisition of land, without direct purchase, whatever, Lordship, nothing has been done. Now, Lordship, they have issued a notice. Notice upon all the petitioners for, Lordship, the direct purchase of the land so that land can be utilized for construction of the bridge. Lordship, we have initially the writ petition was filed in the year 2015 that we have challenged this notice. Now there is a direction for affidavit.
That is completed.
Now affidavit has been complete. I have come with the.
But today it is appearing
Now,
for.
Lordship, 2020, what happened? Lordship, in the COVID period, one of the petitioner expired. Petition number 10 expired. Now, Lordship, this substitution application we have filed. Now, there is a delay in filing the substitution application. Why this is delay? Because first of all, in the COVID period, Lordship, the entire, Lordship, the communication was stacked. Now, one of the petitioner also met with an accident. Lordship, kindly come my application for section 5.
Can 2.
No, 4. This is can 4. Sorry, can 3. Sorry. Because the number has been given first application, section 5 number has been given, then restriction, then substitution application number. Can 3.
Substitution application. Can 3. Can 4 is the section 5.
Yeah, my lord, this cannot be identified as.
Okay, whatever, maybe you can proceed. I can
Now,
understand.
Lordship, the kindly come. Lordship, the paragraph 3
Section 5.
of section 5.
No, this is substitution.
Yes, substitution application. Substitution, section 5 is substitution. Kindly come section 5 application.
Yes.
Lordship, the petitioner number 10.
Amit Ranjan Pakira.
Pakira expired. Expired on 17 July 2020 due to COVID. Now, Lordship, kindly come paragraph 4. That one family member of the petitioners, namely Divyendu Pakira, had met with an accident on 16 June 22. And for a long period of other petitioners are under shock. Due to such accident, Dipendra Pakira, who is still bedridden condition, presently he is in medical treatment. Now, Lordship, kindly come paragraph 5. The Kamal Pakira, who is the petitioner number 1, who is the aged about 90 years. Other family members, including petitioners, are looking after and taking care of him. Another petitioner also cultivated, dairy laborers. They had no knowledge about the legal proceeding and mandatory provision of the substitution application, has to file within the statutory time period. On 20th May 2015, the surviving petitioner came to the chamber of the learned advocate on record. On query, they told the learned advocate regarding the death of the petitioner number 10, Amit Ranjan Pakira expired, and due to absence ground, they not contact with the learned advocate for the petition. Now, Lordship, subsequently, the substitution application filed in a delayed period of 1433 days, that is 3 years, 11 months, 2 days. That is, I have stated in paragraph 7.
Yes.
Lordship, kindly come the death certificate at page 15. Now, Lordship, Kamal Pakira, who is the petitioner number 1, is aged about 90 years. They are the medical papers. Several medical papers I have annexed.
Yes.
Accident. And Lordship, one of the petitioner met with an accident, Dipendra Pakira. Lordship, this medical paper starts from page 44, Lordship, or several medical papers are there. 44.
So this is the ground.
This is the ground. Now, Lordship, I have filed a substitution application. Lordship, kindly come substitution application. Kakoli Pakira is the wife and Aditya Pakira is the son.
Of deceased petitioner 10.
Yes.
Amit Ranjan Pakira.
Yes. Now, Lordship, I relied upon a judgment of during the COVID-19, the Honorable Supreme Court suo moto initiated a proceeding, and Lordship, up to February 2020, Lordship, directed to that all the
Condone all the delay and everything.
Yes, sir. So I have come with this order also, not entire order, one of the last order. Arbitration.
Yes.
So my prayer is let the substitution application be allowed after condoning the delay and setting aside the abatement. Now, Lordship, so far the writ is concerned, in writ petition is concerned.
My lord, only thing, my lord, I want to submit something, my lord, regarding the substitution application, my lord. If your lordship, my lord, kindly came to paragraph 5 of can 3, my lord.
Substitution application.
Yes, my lord.
Yes.
My lord, kindly see the explanation. May I read for you, lord? It mentioned that Kamal Pakira, petitioner number 1 herein, for present about 90 years.
You are reading paragraph 3.
Paragraph 5.
Paragraph 5. Yes.
The section? Section 5 of the substitution.
Section 5.
So, full numbering will have
Yes. Yes.
এই তো এইখানটা পড়ছি এই 3 নম্বর তো আমি লিখেছি এখানে
ঠিক আছে
application.
একটু মোটা বাঁশটা আছে এটা
Motor
প্যারাগ্রাফ 5 পেজ 9
page 9 paragraph. But it be it mentioned that Kamal Pakira petitioner number 1 herein, presently about 90 years old, aged person, other family members including the petitioners has to looking after and taken care of him, and the other petitioners are cultivators and daily laborers, and they have no knowledge about the legal procedure. But my learned friend has given Milad explanation about 2 other petitioners. One died and one Kamal Pakira, and there are 10 numbers of petitioners. There is nothing to say about 7 petitioners also. They can also reside in the locality. They had the knowledge about the death of the Amit Ranjan Pakira. But there is no statement with regard to that, first of all. And Milad, if your lordship kindly consider the petition for setting aside abatement, in which, in paragraph, is contradictory to earlier paragraph. Milad, paragraph 4, what he has stated, Milad, that the applicants are major and sui juris and have the locus standi to move this writ petition against the respondents. The father of the applicants herein, that the petitioner number 1, petitioner number 10 died on 17th of July due to COVID-19, and subsequently one relative of the family members had met an accident on 11th of June 2022 and got injured severely, and for which his treatment is still continuing. Petitioner number 1, Kamal Pakira, is now 90 years aged person, and due to non-availability of the other petitioners for the work purpose residing different places. Well, they are residing in the locality. They all are there present, Milad, for which applicant could not be contacted with time and the instant application, it could not be filed. So there are 2 different statements, Milad. In 2 petitions, they have taken different stands.
Okay. This is your objection.
Yes, my lord.
Very good. Yes, Mr. Talukdar.
normally I do not oppose in such a situation.
You should
but
not.
one explanation is lacking. Milord, this was after that 17 July 2020, Kamal Pakira died. The year is sorry.
Amit Pakira.
Petition number 10 died.
Yes.
Thereafter, on 5th occasion, 5 occasion matter came up. From my brief, Milord, I find in 2 orders, 23rd November and 30th November, the petitioners were represented by the learned. But the fact of this death was not communicated.
Yes.
And in the application, none of these application, there is any whisper why the learned advocate on record could not mention that explanation is
After this paper. Very good.
rest I
Also, kindly come paragraph 6 of section 5. I have stated 20th May 24. Also, they have intimated me that this for number 10x. First petition number 10x. That is 20th May 24. After the application, it was initially dismissed for default. When I called them to restoration, then they have stated the application.
Very good. Please take down. Can 3 of 2024, this is an application for substitution on the date of one of the writ petitioner being petitioner number 10, namely Amit Ranjan Pakira, expired on 17/7/2020. Full stop. Next para, can 4 of 2024 is an application under section 5 of Limitation Act for condonation of delay of 1433 days for filing application for substitution within bracket can 3 of 2024. Full stop. Learned counsel for the petitioner submits that the petitioner number 1, aged about 90 years old, actually looking after the case, looking at the case on behalf of the other petitioners. Full stop. Petitioner number 10 has expired on 17/7/2020 due to the COVID pandemic. Full stop. He further submits that other petitioners are not aware about the legal proceedings, reasons thereof. They could not give proper instruction to the learned counsel. They have also demonstrated on ground that a close relative of the petitioners, namely Divyendu Pakira, had met an accident on 11/6/2022, and after such accident, said relative is under medical treatment. The petitioners are under shock due to such sudden accident. Petitioners are under shock due to such sudden accident. Thus, they could not instruct learned counsel properly. This is the reason the application for substitution was filed in delay. Learned counsel for the petitioner has also argued that during the COVID pandemic, the Honorable Apex Court in suo motu proceeding has condoned the delay of all applications till February 2022. Full stop. He submits that the petitioners the petitioners are always eager to proceed with this matter at this juncture, as the application for substitution was not made within the specified time. Abatement has been caused. He prayed for setting aside the abatement and for substitution of disease, legal heir of disease, petitioner number 10. Full stop. Strong objection raised on behalf of the respondent number.
Respondent number 3.
Respondent number 3, who submits that.
Sorry, 2. Then 2.
Respondent number 2.
Respondent number 1.
1 or 2.
1 and 2.
1 and 2.
1 and
1 and 2. Respondent number 1 and 2 within bracket Chandannagar Municipal Corporation or municipality. Municipal corporation. Chandannagar
1
Municipal
and 2.
Corporation. He submits that there are contradictory statements in Can 3 and Can 4 of 2024. He submits that other than petitioner number 1 and petitioner number 10, other petitioners are the major person. Other petitioners are the major persons, and they were well aware about the pendency of the instant litigation. For that reason, the instant application is not bona fide and liable to be dismissed. Full stop. Learned counsel appearing on behalf of the respondent number 3. Respondent number 3, KMD, submits that after the demise of respondent number 10, this matter appeared before this court at least more than twice.
More than four occasions.
On 4 occasions. In all the occasions, the petitioners were represented through learned counsel.
In 2 occasions, as it appears.
Okay.
In 2 occasions.
In 2 occasions, the petitioners were represented through learned counsels. Full stop. In all 2 occasions, the learned counsel never informed regarding the demise of petitioner number 10. It submits that the instant applications being Can 3 of 2024 and Can 4 of 2024 are not bona fide, so they are liable to be dismissed. Having heard the learned counsel for the parties and considering the grounds mentioned in Can 4 of 2024, it appears that the respondent number 10 was expired on 17/7/2020.
Petitioner number 10.
Petition number 10 was expired on 17/7/2020. Admittedly, the period is within the COVID pandemic. Full stop. It is well known that the Honorable Supreme Court has passed an order in a suo motu proceeding, thereby all applications all applications required to be filed within that period has been if there be delay, the same has been condoned by such order. It further appears that the petitioner has demonstrated in the application it further appears that petitioner has demonstrated the fact that petitioner number 10 is 90 years old, and the petitioners are also under shock due to one sudden accident of one of their relatives. The documents of accident has been placed on record along with Can 4 of 2024. Full stop. The learned advocates for the respondent has not contradicted the fact. Considering the same, it appears to me that the grounds as mentioned in Can 4 of 2024 are sufficient, and thereby the delay in preparing the application being Can 3 of 2024 is hereby for 1433 days is hereby condoned. Full stop. Next, accordingly, the Can 4 of 2024 is allowed and disposed of. Next para, Can 3 of 2024. This is an application for substitution. Full stop. The petitioner number 10 has expired on 7/7/2020. The applicants, namely applicants, are the applicants mentioned in paragraph 3 of Can application 3 of 2024 are the wife and son of deceased respondent number 10. Being the legal heir, they are required to be substituted in the cause title of the writ petition at the place of respondent number 10. Under the above observation, the Can 3 of 2024 is considered and allowed. Full stop. Allowed. The abatement, if any cause due to the death of respondent number 10 is hereby set aside. Full stop. The substitution be allowed. Full stop. The applicant, namely Kakoli Pakhira and Orithro Pakhira, be added as respondent number petitioner number 10A and 10B in the instant proceeding. Full stop. Writ petitioner is directed. Learned counsel, learned advocate on record for the writ petitioner is to correct the cause title of the writ petition within a week. Full stop. What is the accordingly the Can 3 of 2024 is disposed of. What is the status of pleadings?
This is the evidence reply against the opposition filed by the
Opposition filed
Yes,
by both the parties.
and
because in that case, I'll hand you over the
of the at least cost title, amended cost title to the parties, so that
Okay. The petitioner is directed to serve the amended cause title, amended copy of writ petition upon all the respondents. Full stop. Next para, ever korun. WPA 8834 of 2015. Affidavit in reply filed on behalf of the petitioner to the affidavit in opposition filed by respondent number 1 is taken on record.
opposition, affidavit in opposition.
KMD opposition দিয়েছে
This is my opposition on behalf of the corporation.
only the reply to the KMD is lordship we have to
তাহলে এটা just wait. প্রথমে করুন affidavit in opposition filed on behalf of the respondent number 1 1 and 2 Chandannagar Municipal Corporation be taken on record. তারপর এটা করতে affidavit in reply filed by the petitioner. So the petitioner is at leave to use the affidavit in reply against the affidavit in opposition filed by respondent number 3 within a fortnight.
No, Lordship, kindly, here, long time it is running, Lordship, kindly fix the next week. In the meantime, we affirm the reply and submit.
Within a week. Within a week.
Within a week.
Let the matter appear in the list on 31st.
Yes.
Under the heading hearing.
Yes, my lord.
Item number 7, my lord.
Item number 19. Long. Let it be called, otherwise I cannot do this matter. It will appear next week.
Well, item number 7 is a restoration application. Well, state was directed to file affidavit in opposition, but till date it has not been filed. Well, and I am carrying the affidavit of service. Well, this can be restored. Well, I am suffering since 1983. Nobody has given the compensation has not been paid. Possession has been given to them.
Which for the state?
Mr. Chondicharan, they last appeared. There was a direction on 10th January 2025. Now, only urgency is that all these are cultivators. They are at hand to mouth. Their condition is very
Now
bad.
you
Yes.
take the
I'm just if can be.
If Mr. Day is there, I can
Yes,
dispose
yes.
of this matter.
Very
Otherwise, it will appear Thursday.
Well, he is appearing.
No.
Oh no, not
It
Lordship,
will
at the
appear
cost of,
Thursday.
at the
on the
cost
same
of
heading.
being reprimanded, your
There are some difficulty on that.
Yes, Lord, yes.
So that I
Otherwise,
can
your
take
lordship.
up this matter. Otherwise, I could
Very
dispose of all the applications.
Very
Your Lordship, at the cost of being severely reprimanded, I reprimand myself for doing this. Your Lordship, item number 8, it was an ex parte order passed by your Lordship on 8th of May 2025. This is my simple application for extension of time to make the representation before the competent authority.
Okay. Item number 8
8, your Lordship.
is appearing under heading application. What application?
The application just for extension of by your Lordship's order dated 8th of May 2025, your Lordship had directed us to approach the competent authority making a representation within 3 weeks. We've not been able to do it within 3 weeks. Ex parte order your Lordship had passed because they were not appearing. NHAI was not appearing. We've not been able to do it.
So what you want? Extension?
Just extension.
Come on Thursday. On Thursday. Next Thursday.
Grateful.
Okay.
Grateful.
Yes.
Thank you, Asif.
Last of the two.
19th June order. আজকাল সব থাকে
So who is for the state?
I complied with lordship's order. I don't find anybody. report করা যায়? I remind you, Lordship, on deed they are saying, which is not never seen the light of the day. It was not on that, on the basis of subsequent.
They are saying in the record the
But from
partnership.
this card, was never acted upon, never. But the license was granted, it was continuing with the file deed, which I am relying on.
April 12, 2024 is the deed they are referring.
That was never seen the light of the day. They never approached them with that. For the first time, a letter was sent in 2024. Without that record, my lord, I think nothing could be done.
So what can be done today?
My lord is asking me, my lord is the,
No, I know I have the authority to pass any order.
that's all.
But what would be the justification?
That,
That would the justified order has to be
that
passed.
I have.
That's why I want to know it from
It
you.
would be better, my lord, if you also direct the principal secretary to file a report, because the authority who has directed to file a report has not filed. We have communicated your lordship's order. Think, my lord, the principal secretary who has passed the order may be directed to file a report. We will again communicate. I will not ask your lordship to pass this matter ex parte.
This is no, this is the secretary food and supply. Principal secretary you have served.
That is secretary.
Okay. This is the principal secretary.
Yes.
He is the principal secretary. You have served.
Sir, that is the order communication.
Very well.
I think so.
Please take down. With the order dated 19th of June 2025, this court has observed that without a report from the state authority in respect of the issue involved herein, the matter cannot be disposed of. In terms of the direction of this court, the petitioner has served upon the Secretary Food and Supply Department, Government of West Bengal. Full stop. In spite of service, none appears on behalf of the state.
The last chance.
Full stop. Considering the situation, the Principal Secretary, Food and Supply Department is directed to submit a report on his own accord in respect of the merit of this matter, unless which the matter would be taken up on merit on the adjourned date. Full stop. Let the order be served upon the principal secretary as well as upon the learned legal remembrancer, informing the matter that informing the fact that none represent the state of West Bengal before this court today.
Instead of legal remembrance, it should be advocate on record. This is original side. Advocate on record of the state.
Advocate on record you have already served at the time of filing. of
Yes,
the-
but again I have to serve because they are not appearing. In appellate side, legal remembrancer can be
Advocate on record
of the state of West Bengal.
for the state of West Bengal, containing the fact that none appears on behalf of the, no one represent the state before this court today. হয়েছে? এখন the matter be adjourned today, list the matter on twenty-fifth at 2 p.m. 25th of July 2025 at 2 p.m. 2 p.m. কি আছে? ওটা থাকা এটা থাকবে এটা আগে হবে ওটা পরে এটা ফার্স্ট ম্যাটার ওটা সেকেন্ড ম্যাটার
কি করবে কি করবে আরে চাল দাও এখানে থেকে দেখো লাভশিপ হ্যাজ nothing to do, but if the state does not appear,
Yes.
the state to answer.
then I will pass the order
But
on that date.
ex party no ma'am. My lord will travel again with an application, recall is
yes.
that. Grateful.
Supplementary appeal.
Yes. So, Mr. Surana, you want to demonstrate some points.
Okay. Thank you for that. What the interest rate?
So, Pantaloon has paid 1.93 crore already to the bank, but not according to the contract, not according to the agreement.
They have not paid 1.93 crores to the bank. They have paid to me also, to the bank also.
Yes.
To the bank means there is a clause in the agreement that the license fee can be paid to the bank because I have taken loan from them,
Yes.
and repayment of loan was tagged with the future rent receivables. So they were fully aware that I have taken a loan from the bank, and they have agreed to make the payment to the bank. That is page 42, 43 of my statement of claim below.
Yes.
Their letter is there of 16th of February 2007.
No, this issue you want to demonstrate further?
No, I just wanted to state something different, Milo.
Regarding payment of interest.
No, I'll come to that, Milord. First of all, I have made extensive submissions on group of companies, Milord.
Yes.
Fine. Now, recently, Future Group had a dispute with Amazon also, and an arbitration was going on in Singapore. The Singapore arbitration has made an award, Milord, wherein they have, wherein the learned arbitrator has said there that he also told 11 promoters and parties of the future group, including Kishore Biani, to pay the amount along with interest from so and so date.
This is the judgment,
This is a copy of the award, my lord.
copy of award.
This is a short article which has appeared in the news. I cannot have the copy of the award, my lord. But then this is a very famous arbitration went on for years together, where all stalwarts have participated.
Singapore International Arbitration Center.
My lord.
No, how this court can based upon these?
But this is an arbitral award, my lord.
So arbitral award, that is the that we can construe as foreign judgments. There are some parameters to understand and based upon some foreign judgment.
And the parties are from Calcutta, from India, future group, the same which is there in my case also, the same party, future group, my lord.
So, no, what do you want to submit?
I just want to submit here, my lord, that in group of companies, the current respondent, they say that we have left the premises, we are not responsible. Whereas Justice Banerjee, in his order on 21st of March 2012, has held that all the 4 entities are jointly or severally
Yes, you have
liable.
shown me that.
And this they have challenged in the division bench, they did not succeed.
Yes,
they went to Supreme Court, they did not succeed. And in the arbitral award also, it is stated that they are responsible jointly or singly. Now, what I wanted to humbly submit, my lord, in this award, Singapore arbitration is very famous. Singapore and London, these are the 2 famous places where arbitration takes place, and where all stalwarts and all big companies are involved here. So here, my lord, the arbitrator has said he also told 11 promoters and parties of the future group, including Kishore Biani, to pay the amount along with interest from so and so March. And then, my lord, Amazon was awarded 77.3 crores and Singapore dollar 68,550 as litigation cost. Both are in bold, I have stated in this, my lord.
Yes.
Now, if the cost is awarded at 77 crores, one can imagine who has participated in the arbitral proceedings, my lord. And I am also concerned with this because Reliance Group has made an agreement with Future to buy the entire properties of Future Group at 24,500. But Amazon said, no, you cannot do that. So that arbitration was going on, and this is the result of this arbitration. So why I am producing this, that as a group of companies, my lord, not only the group of companies, even the promoters have also been held liable for making the payment of the award. And secondly, my lord, disclosure of documents, volume 2 ache, 14 page. এটা বড় আছে, ছোট পেজে আছে। Yes, এখানে পেজ 21।
Yes.
Now, my lord, this is a letter which has been filed by Future Retail in the Bombay Stock Exchange and National Stock Exchange. Here, they have stated the name of the companies which are under their control, all group companies. So my humble submission is, my lord, that all these group companies are liable for payment of my dues. Unfortunately, 3 of these respondents have already gone into CIRP process. Only one is left out.
Yes.
And this is a document which is on record, my lord. And this is filed by them only. And wherein they have clearly stated entities C, A, B, C. C is entities over which key managerial personnel are able to exercise significant influence, the name of the companies. Then in E, it is stated key managerial personnel is Kishore Bihani, Rakesh Bihani, Gagan Singh, Ravindra Dhariwal, Shailendra Bhandari, Sri Dev Patida, Rahul Garg, CP Toshniwal, Virendra Samani. So my humble submission is, my lord, that my claim has to be met by individually or jointly, and all these companies are responsible. They are all group companies, my lord. And I have also filed before your lordship judgment, Constitution bench judgment delivered in Cox and King Limited, my lord. As far as my cost is concerned, my lord, I have been awarded nil cost. And what the learned arbitrator has stated
Litigation cost. Litigation cost.
Yes, cost of arbitration, litigation. I'll just place before your lordship the relevant volume 1 and 2 दिए थे 822 से petition. But the cost, my lord, the learned arbitrator is stated at page 110, my lord.
Yes.
The relevant paragraph is 109, my lord. Both parties have conducted the proceedings in a most irrational manner, resulting in a prolonged hearing. Both parties had given me to understand at the initial meeting that the hearing would be concluded within a period of 15 days. Unfortunately, the proceedings dragged on 82 sittings. Accordingly, I direct that parties should bear their own cost. My lord, if a claim is refused, is not admitted, a proper reason has to be given, which is the requirement of section 31C of the Arbitration Act, my lord. Now, this is no reason that both parties have conducted the proceedings in a most irrational manner. 82 sittings. It was held before the arbitrator. And the respondents were led by a senior advocate of this honorable court, my lord. Up to a certain extent, up to probably 43 or 44 sitting, I was also led by a counsel of this honorable court, my lord, and thereafter I have proceeded. Now, in all, my lord, I have paid a sum of rupees 19,15,330 to the learned arbitrator as my share of cost. And equally, they have also paid. And I have also paid 93,500 as venue charges. And I have also paid around 10 lakhs as litigation costs up to that stage where my consuls were there. I believe your lordship has noted this 19,15,333, my lord.
Cost you paid.
I have paid 19,15,333. 1915333 to the learned arbitrator. And I hope the equal amount has been paid by the respondents also. And I have also paid 93,500 as venue charges.
Yes.
And I have paid around 10 lakhs to my legal team also.
Yes.
And Milord, I am entitled with the cost of the arbitration. Normally, the party who succeeds, he gets the cost under section 31A, 31 capital A, Milord. Nothing has been given to me, Milord.
Yes.
So my humble submission, Milord, under the Act 1996, to be precise enough, under section 31 capital A cost is to be given to the party who succeeds in the arbitration. And if the cost is refused, certain reasons have to be stated. Now, they did not participate fairly, this and that, and all this is not a reason, my lord. This, I would say, this is absolutely an unintelligible order, as has been stated in Divya, my lord, Divya Technologies by Honorable Supreme Court. The award must be intelligible. And I have also filed a judgment of ONGC versus SAP ICE before your lordship, my lord. That also indicates if the award is contrary to the substantive provisions of law or the provisions of the Act or against the terms of the contract, it would be patently illegal, which could be interfered under section 34.
Yes.
So my humble submission, my lord, I am entitled with the cost set. Now I come to interest, my lord. The award paragraph is 107 and page 109, my lord. निकालो इसमें 19. Can I place it, my lord? Paragraph 107 of the award, my lord. By reason of the foregoing analysis of events and on basis of evidence, both oral and documentary, I have come to the conclusion that the claimant was entitled to a sum of rupees 18 crores, taken together all items of claim, while the respondents were entitled for 5.26 crores on account of their claim for set-off and counterclaim. In this context, I wish to record that having regard to the erratic and irregular fashion in which both parties conducted themselves in discharge of their contractual obligations, be it payment of rent or repayment of loan, I found it practically impossible to calculate interest in any of the terms of claim or set-off, notwithstanding provision for paying interest was provided for in the agreement dated so and so, or in any other entered into them between or other entered into by them since then for allied transactions have in my estimate of damages I have accordingly ignored. Now, my lord, by this I submit that arbitrator was fully aware that there is a clear provision for payment of interest in the agreement. And if there is a clear provision in the agreement, let me place that clause, my lord. Paragraph 19, my lord, at page 122, volume 2, my lord. Paragraph 9, clause 19.
Clause 19.
Clause 19 of my agreement, my lord, at page 122, volume
Yes.
2, my lord. Can I place it?
18%.
18%, my lord. So my humble and 18% from the time from the date it becomes due. The last line I am just reading, my lord, of that clause. In case licensee condones the default of sub-licensee, then and such event the sub-licensee shall along with such dues and arrears pay compensation for the loss and or damages suffered by the licensee and also interest at the rate of 1.5% per month for the period of default on all amounts remain outstanding, unpaid. So the learned arbitrator was fully aware of this condition, my lord.
Yes.
And it is not a ground that having regard to the erratic and irregular fashion in which both parties conducted themselves in discharge of the contractual obligations, be it the payment of rent or repayment of loan, I found it practically impossible to calculate interest. The arbitrator was not liable to calculate the interest. He was only entitled, he was only authorized to pass an award conveying payment of interest so and so on so and so amount from so and so date only. And that has been done in respect of the overall sum of the award, which is there in page para 108, my lord. That 18% on this amount. No calculation has been done by the arbitrator. Earlier also he was not required to calculate the interest also. He was only required to award the interest from the date on a sum from which it has become due in terms of the contract.
He has awarded interest from the date of award.
From the
Till
date
the payment.
From the day post award is there.
Post award.
That means the requirement of section 31(7)(b), my lord. But arbitrator is also authorized to award pendentality and prior to the arbitration also, my lord.
31(7)(a).
That is 7A, my lord. And 7A has not described what is the rate he can give. But if the rate is stated in the award, he is bound by that only. Otherwise, he has the jurisdiction to award any amount, maybe 1%, 10%, 20%, whatever it is. But since it is there, he is bound by the contractual conditions. I have also filed before your lordship a judgment of Hyder Consulting, my lord. Hyder Consulting, your lordship has that. I have an extra copy. Hyder Consulting UK Limited versus Governor of Assam. Extra copy. Hyder Consulting. याद आपको एक वर्ड इसका.
Yes.
Paragraph 33 at page 9, my lord. This is the judgment of 3 judges. Justice Dattu has given a different judgment, and Justice Bopte and Justice Sapre has also given a separate judgment, my lord. Now, I am referring to paragraph 33 at page 9, my lord.
Yes.
Subparagraph 19, my lord. Section 37(1) SC of the new act, by using the words unless otherwise agreed by the parties, categorically clarifies that the arbitrator is bound by the terms of the contract in so far as the award of interest from the date of cause of action to the date of award. Now, this has been cited from a judgment delivered by the Honorable Supreme Court in Sri Kamakshi Amman Construction, which is there in the stated in paragraph 33, my lord.
Yes.
So it is very clear, my lord, that categorically clarifies that the arbitrator is bound by the terms of the contract in so far as the award of interest from the date of cause of action to the date of award. Now, in my case, my lord, the area was specified, the rate was specified, and when they are required to make the payment is also specified in clause E4 of my contract, my lord. That they were liable to make the payment of license fee by 10th day of every month. So I am entitled to interest right from the 11th day of the succeeding month, my lord.
Yes.
Now, my lord, I would also place few paragraphs of Justice Bobde and Justice Sapre at page 18, my lord, of the same judgment. Paragraph 13, my lord.
Yes.
Thus, it is apparent that while clause A of section 7, subsection 7 of section 31 of the Act, Parliament intended that an award for payment of money may be inclusive of interest, and the sum of the principal amount plus interest may be directed to be paid by the arbitral tribunal for the pre-award period. Thereupon, the arbitral tribunal may direct interest to be paid on such sum for the post-award period, while clause B of the subsection 7 of section 31 of the Act, at which stage the amount would be the sum arrived at the after merging of interest with the principal. Well, the whole explanation here is when the award is given, say, for 100 rupees, and when the award has been made prior to that period, if amount is, say, 25 rupees, that 25 is added with the award sum, that becomes the award sum 125 rupees. Now, subsequent period under section 31(7)(b), I am entitled for the sum of the award, that is 125.
Yes.
Maybe it will be interest on interest. This is the clarification which has been given by Justice Bobde and Justice Sapre.
Yes.
Can I place the other paragraphs also, my lord?
Yes.
14. In fact, this is a case where the language of subsection 7 clause A and B is so plain and unambiguous that no question of construction of a statutory provision arises. The language itself provides that in the sum for which an award is made, interest may be included for pre-award period, and that for the post-award period, interest up to the rate of 18% per annum may be awarded on such sum directed to be paid by the arbitral award. In such a situation, one is reminded of the decision in Ganga Prasad Verma. I am not placing that. Second paragraph, subsequent paragraph. We may also refer to the decision of Privy Council in Pakala Narayan Swami versus Emperor, wherein Lord Atkin observed that when the meaning of words is plain, it is not the duty of the courts to busy themselves with supposed intentions. This view was upheld recently by this court in TN State, Tamil Nadu State Electricity Board versus Central Electricity Regulatory Commission. Then, my lord, page 19, paragraph 15, my lord. In the result, I am of the view that SL Aurora's case is wrongly decided in that it holds that a sum directed to be paid by the arbitral tribunal and the reference to the award on the substantive claim does not refer to the interest pendentality awarded on the sum directed to be paid upon the award, and that in the absence of any provision of interest upon interest in the contract, the arbitral tribunal does not have the power to award interest upon interest or compound interest either for the pre-award period or for the post-award period. Parliament has the undoubted power to legislate on the subject and provide that the arbitral tribunal may award interest on the sum directed to be paid by the award, meaning a sum inclusive of principal sum, adjust, and the interest. And this has been done by the Parliament in plain language.
Yes.
Page 20, my lord.
Yes.
Page 20, my lord. क्या बोलते हैं?
Okay, I have the copy.
Paragraph 5 at page 20, my lord. Section 31(7)(a) of the Act deals with grant of pre-award interest, while subsection B of Section 7 of the Act deals with grant of post-award interest. Pre-award interest is to ensure that arbitral proceedings are concluded without unnecessary delay. Longer the proceeding would be the period attracting interest. Similarly, post-award interest is to ensure speedy payment in compliance of the award. Pre-award interest is at the discretion of arbitral tribunal. Now, in my case, my lord, it is stated there. When it is stated, then there is no question of discretion. If it is not stated, arbiter has every discretion, my lord. And one thing also I would like to make it clear, my lord. In my contract, there is nowhere it is stated that I'm claiming I'm entitled for compound interest or interest on interest. But the arbitrator has to consider the correspondence actions between the parties also subsequent to the execution of the agreement. Now, subsequent to the execution of agreement, my bank has written a letter to Pantaloon that I have granted a loan to Surana and the repayment is tagged with the future rent receivables. And they have confirmed we will make the monthly payment to you. So they were fully aware that I have taken loan. They were fully aware they are liable to make the payment to the bank on account of monthly license. And it is also known to everybody who takes loan from the bank charges interest at monthly rest. So this should have been favorably considered by the learned arbitrator. Longer the proceedings would be the period attracting interest. Similarly, post-award interest is to ensure speedy payment in compliance of the award. Pre-award interest is at the discretion of arbitral tribunal, while the post-award interest on the awarded sum is mandate of the statute. The only difference being that of rate of interest to be awarded by the arbitral tribunal. In other words, if the arbitral tribunal has awarded post-award interest payable from the date of award to the date of payment at a particular rate in its discretion, then it will prevail. Else, the party will be entitled to claim post-award interest on the awarded sum at the statutory rate specified in clause B of section 31(7), that is 18%. Thus, there is a clear distinction in time period and intended. So, by this, it is very clear, my lord, that even if rate of interest is not stated, I am entitled to 18% interest from the date of the award. And if it is stated, I am entitled for the pre-award also, for the penalty and pre-arbitration also. And if it is not stated, then arbitrator has a discretion.
Yes.
Page 21, my lord, paragraph 7. Therefore, for the purpose of an award, there is no distinction between a sum with interest and a sum without interest. Once the interest is included in the sum for which the award is made, the original sum and the interest component cannot be segregated and be seen independent of each other. The interest component then loses its character of an interest and takes the color of sum for which the award is made. So long the award is not made, it is interest. Once it is included in the award,
It becomes the award.
it becomes the sum, award sum.
Awarded sum.
And the color of interest is gone there. Paragraph 9, my lord. Therefore, I am inclined to hold that the amount awarded under section 37(1)(a) of the Act, whether with interest or without interest, constitute a sum for which the award is made. 10. Coming now to the post-award interest under section 37(b) of the Act, implies the word sum directed to be paid by the arbitral by an arbitral award. Such clause B uses the words arbitral award and not the arbitral tribunal. This is the difference between that, my lord. The arbitral award, as head above, is made in respect of a sum which includes the interest. It is therefore obvious that what carries under section 31(7)(b) of the Act is the sum directed to be paid by an award sum, by an arbitral award, and not any other amount, much less by or under the name interest. In such situation, it cannot be said that what is being granted under section 31(7)(b) of the Act is interest on interest. It has been made very clear, because interest loses its color once it is included in the award sum, in the award amount. Interest under subclause B is granted on the sum directed to be paid by an arbitral award, wherein the sum is nothing more than what is arrived at under subclause A.
Yes.
11. Therefore, in my view, the expression grant of interest on interest while exercising the power under section 31(7) of the Act does not arise, and therefore the arbitral tribunal is well empowered to grant interest even in the absence of clause in the contract for grant of interest. 12. My aforesaid interpretation of 31(7) of the Act is based on 3 golden rules of interpretation as explained by Justice G.P. Singh, interpretation of Statute 13th edition 2012, where the learned author has said that while interpreting any statute, language of the provision should be read as it is, and the intention of the legislature should be gathered primarily from the language used in the provisions, meaning thereby that attention should be paid to what has been said as also to what has not been said. Second, in selecting out of different interpretations, the court will adopt that which is just, reasonable, and sensible, rather than what is not of one of these. None of those things. And third, when the words of the statute are clear, plain, or unambiguous, that is, they are reasonably susceptible to only one meaning, the courts are bound to give effect to that meaning, irrespective of the consequence. I have kept these principles in mind while interpreting section 31(7) of the Act. So he has made very clear, my lord, Justice Sapre, what is there in the statute has to be read in the right direction. And my clause number 19 in the agreement is not only for interest on rent, interest on the sum remaining due. That includes electricity charges, water charges, CAM, and everything. I have also placed before Lordship another judgment delivered by Honorable Supreme Court in UHL Power Company, my lord. This judgment I placed earlier in respect of my other claims, which were not considered by the learned tribunal. Now, I will also rely on this judgment for payment of interest also, my lord. And I will be referring to clause 2 and 6 and 23, my lord. Clause 2 is paragraph 2, my lord, on page 1.
Paragraph 2. Yes.
Now, these 3 paragraphs I will be reading only for the purpose of interest, my lord. Though several rounds have been taken by UHL in its appeal to assail the impugned judgment, Mr. Jaideep Gupta, learned senior counsel of UHL, has confined his grievances to the disallowance of the pre-claim interest pre-claim interest, that is interest from the date when expenses were incurred by UHL till the date of lodging the claim. It may be noted that in the terms of award dated 5th of June 2005, the learned sole arbitrator had awarded a sum of rupees 26 crore 8,89,107 in favor of UHL towards expenses claimed, along with pre-claim interest capitalized annually. This is important. Interest capitalized annually, Milord. What I understand from this is, Milord, assuming I get an interest, an award for 100 rupees, Milord, and I have been allowed 18% interest on the award till payment. Now the award has been made in the month of May 2016, and if they don't pay within time, then from May 2016 to 31st of March, there will be some interest. That interest will be added with 100 rupees. Now that will become the principal sum, and that interest will lose its color. So that is the capitalization, Milord. Because in mercantile business, Milord, every year we have to make the books of accounts, Milord, and file our returns with the registrar of companies, with the income tax authorities, with the GST authorities, and all this. On the expenses so incurred. Further, compound interest was awarded in favor of UHL at the rate of 9% per annum till the date of claim, and in the event the award amount is not realized within a period of 6 months from the date of making the award, future interest was awarded at the rate of 18% per annum on the principal claim with interest. I'll place paragraph 6, Milord. Paragraph 6 on page 2, Milord. As the judgment in the case of SL Aurora, on which reliance has been placed by the division bench of the High Court, Himachal Pradesh, has since been overruled by a three-judge bench of this court in the Hyder Consulting, which I have just placed before your lordship. The finding returned by the appellate court in the impugned judgment to the effect that the arbitral tribunal is not empowered to grant compound interest or interest upon interest, and only simple interest can be awarded in favor of UHL on the principal amount claimed, is quashed and set aside. As a result, the finding returned in paragraph 54A of the impugned judgment insofar as it relates to grant of interest component are reversed, while restoring the arbitral award on the above aspect in favor of UHL. So here, Milord, interest on interest was given, compound interest was given. And then, Milord, in paragraph 23, last at page 8, Milord, absolutely last paragraph.
Yes.
In view of the above discussions, civil appeal number 10341 preferred by UHL is partly allowed to the extent mentioned in paragraph 6. I have just placed before your lordship now. While civil appeal number so and so filed by the state of Himachal is rejected in toto, parties are left to bear their own costs. So I have also said, Milord, about 31(7)A, 31(7)B, and interest is to be paid, and arbitral award, the arbitrator has a power to grant interest on interest also, Milord. I am placing yet another judgment delivered by Honorable Supreme Court, Milord, in Jaipur Vidyut Vitran Nigam Limited versus Adani Power Rajasthan Limited.
Yes.
I am placing paragraph 2, 3, and 4, Milord. Sorry, page 2, 3, and 4. Page 2, absolutely the last paragraph, Milord. Can I place it?
Yes.
With regard to the question of interest, late payment surcharge, we notice that the plea of change in law was initially raised by APRL in the year 2013. A case was also filed by APRL in the year 2013 itself, raising its claim on such basis. However, the appellants Rajasthan Discoms did not allow the claim regarding change in law, because of which APRL was deprived of raising the bills with effect from the date of change in law in the year 2013. We are thus of the opinion that considering the totality of the facts of this case, and in order to do complete justice and to reduce the liability of the appellant Rajasthan Discom, payment of 2% in excess of the appellate SBAR per annum with monthly rest would be on the higher side. In our opinion, it would be appropriate to direct the appellant Rajasthan Discoms to pay interest for late payment surcharge as per applicable SBAR at the relevant years, which should not exceed 9% per annum. It is also provided that instead of monthly rest, the interest should be compounded per annum. Next page, page 3, paragraph 68, my lord. We accordingly direct that the rate of interest late payment surcharge would be at SBAR not exceeding 9% per annum to be compounded annually, and the 2% above SBAR would not be changed in the present, would not be charged in the present case. So, my lord, here the compound interest has been given. The compound interest annually has been given here, my lord.
Annually compound.
Yes, although there was nothing in the contract. Then, my lord, page 4, my lord. And that is not relevant, rather, but still I will place that, my lord. As such, considering the totality of fact, paragraph 10, my lord, the second paragraph. As such, considering the totality of facts and circumstances of this case, prima facie, we are of the opinion that the respondents are liable for contempt for not complying this court's order. I am not placing this as contempt, and contempt proceedings are also. Should I place it, my lord?
Non.
By this judgment, I just wanted to humbly submit before your lordship that compound interest is also payable by the tribunal and by the courts also. File down so and so.
Yes.
On the earlier occasion, I have also placed a judgment, Madnani Construction versus Union of India, my lord. This is also on compound interest, my lord. Interest on interest. Madnani. And see, if I have additional copy, I'll try to. आगे देवा चलो देखो ये मदनानी कंस्ट्रक्शन P191 আমাদের এই যে আছে না AB judgments আছে না 191 The relevant page is 192, my lord.
One
192 on the top, my lord. Just 3
Yes.
lines below. The learned arbitrator gave his award on 13th of April 1992, holding that the railway should pay an amount of praise 4,48,873 along with compoundable bank interest prevalent at that time from 83 to 92. So this categorically shows, my lord, that there were certain amount of correspondence. The arbitrator was aware that bank loan has been taken, and when bank loan has been taken, the interest is always compoundable. Yes. Then paragraph 6, my lord, on the same case, the subparagraph of 6, my lord, the railways filed an application before the district judge for transfer of the application filed by the contractor under section 20 of the Act and under section 24 of the Civil Procedure Code. It was dismissed on 13th of November 1992. The railways filed an application on 23rd of November 1992 before the court below for summoning the application, and under section 30-33 of the Act, this is under 1940 Act, Miller, of the Act, from the court where it was filed. This was objected to by the contractor on the same date. However, the court below summoned it and not only rejected it, but also rejected their objections against the application under section 17 of the Act. The court below, by its order dated 1st of December 1992, also pronounced judgment according to the award and decreed interest at the rate given by the bank from the date of the award till actual payment. On 1st December 1992, the senior judge Gorakhpur of the Court of Just Small Causes Gorakhpur made the award a rule of the court. Then at page 10, my lord, at page 200, the last paragraph, my lord, paragraph 58, page 200. Yes. In view of such consistent views taken by the Constitution Bench judgment in G.C. Roy and N.C. Badaraja, we are of the view that the facts of this case, no interference is called for which award passed by the arbitrator. The judgment of the High Court is therefore set aside and award is upheld. Appeal is allowed.
There is also compound interest.
That is also compound. Compound interest was given and it was upheld even by the Supreme Court, my lord. A117. A117. Our judgment is आगे A245 देन A245 आगे A245 दे देन A245 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 पेज 245 245 Yes. I mean, this judgment I have placed earlier on many occasions while when several claims were being discussed. It starts from page 239, my lord.
Kranti Association.
Yes, my lord. Kranti Associates.
Yes.
I just rely on one sentence, my lord. That is paragraph 51B and L. Paragraph 50B is at 245.
Yes.
This 51B, my lord. A quasi-judicial authority must record reasons in support of its conclusion. L, my lord. At the absolute bottom, my lord. Reasons in support of decision must be cogent, clear, and succinct. A pretense of reasons of rubber stamp reasons is not to be equated with a valid decision-making process. I mean, unless the reasons are given, it will be very difficult for your lordship to come to a conclusion why it was given, why it was not given. And if reasons are given, your lordship can analyze what is right, what is wrong. The identical things, my lord, are there in ONGC judgment which I have cited before your lordship, my lord. I'll just read it, my lord. At page 117, what is recorded here is, if the award is contrary to the substantive provisions of law or the provisions of the act or against the terms of the contract, it would be patently illegal, which could be interfered under section 34. It was further held that it is open to the court to consider whether the award is against the specific terms of the contract, and if so, interfere with it on the ground that it is patently illegal and opposed to the public policy of India.
Yes.
But the arbitrator is a creature of an arbitral agreement. He is to go by the terms of the contract. And the same judgment, my lord, at page A130, it is stated, it is to be reiterated that it is the primary duty of the arbitrators to enforce a promise which the parties have made and to uphold the sanctity of the contract, which forms the basis of civilized society and also the jurisdiction of the arbitrators.
ONGC case.
ONGC. At page 130, my lord. And likewise, this there in Southeast Asia marine engineering, which I have placed.
All
my lord.
judgments,
But I have
reasons is
placed that
required to.
an arbitrator has to act within the four corners of the contract, my lord. And I have also placed before your lordship Union of India versus SL and Murthy, my lord, where it is stated, however, the award which is on the face of it patently in violation of statutory provisions cannot be said to be in public interest. Such award judgment decision is likely to be adversely affect the administration of justice. Hence, in our view, in addition to narrower meaning given to the term public policy in Renu Sagar case, it is required to be held that the award could be set aside if it is patently illegal. You have already placed those. I have placed in other things also. And above all, my lord, there is a clear provision for payment of interest in my agreement. And I have also placed before your lordship a judgment given by Honorable Supreme Court in Indian Oil Corporation versus Sri Ganesh Petroleum, where also they have said the arbitrator is required to act within the terms of the contract, my lord. And the same thing was in Union of India versus DM Reverie. I have stated this is a commercial contract. The arbitrator cannot deny what is there in the contract, my lord.
Yes.
So my humble submission, my lord, as far as interest is concerned, whatever has been stated in the award does not meet the requirements of section 31(3) of the Act. No cogent legal reasons have been provided. My agreement clearly contains payment of interest when the sum becomes due. And the rate of interest has also been clearly stated in the agreement.
Yes.
And when I have taken, although compound interest theory is not there in my contract, but it is there in the correspondence. The respondents were aware that I have taken a loan from the bank and I am liable to pay compound interest to the bank. They have agreed to make the payment to the bank, which is there in page 42, 43 of my statement of claim, volume 1, million. I have placed earlier also. Should I place again, million?
Not necessary.
So they were aware of that. And I have also placed before your lordship the judgments of Honorable Supreme Court, especially that Jaipur Nigam, where although it was not stated in the contract, the Supreme Court has allowed compound interest. And the arbitrator has a choice, has a discretion for awarding interest under section 31(7)(a) if it is not there, if it is not stated in the contract. He can award any rate, maybe 5%, maybe 10%, maybe 12%, maybe whatever it is. But if it is there in the agreement, he is bound by that. Unfortunately, my lord, the rate of interest has been categorically stated
In the agreement itself, under clause 19.
Under clause 19, my lord. My lord, I have also stated when I was discussing about they have said that they have given me a loan of 1.6 crores. And I have said that, yes, I have received the amount. They have already recovered this money from my license fee. So when the loan has already been recovered, there is no point that they can raise again, number one. In spite, other than this, my lord, I have submitted before the learned arbitrator that the theory of loan is not covered by the agreement. So this is outside the agreement. The arbitrator is not empowered to consider that. Number one. Number two, I have also placed before your lordship the date of payment of those loans. That is stated in my agreement at page, my lord, 9. I'll just place volume 1 there. Page 9.
Yes.
Now, my lord, they have given me 1 crore 40 lakhs. When 50 lakh was given to me on 26th of May 2008, 50 lakhs was given to me on 30th of April 2008, and 40 lakhs was given to me on 7th of June 2008.
Yes.
Well, for this, there is no document of loan executed. But I have requested them to give me 1 year's rent as advance on account of loan. They refused to give me. They said, we will give you loan. And which is there, they have stated, my lord, at page 74 of this, my lord. Page 74 of the same volume, my lord.
So in the statement, they have said that respondent number 1 agreed to pay 1 year's rent in advance.
Yes. Now, my lord, 1 year's rent in advance is also not covered by the agreement.
Yes.
Right? But since I have demanded, if they accept, I am still prepared to accept it. But it was not considered by the learned tribunal. The learned
They have paid 1 crore 40.
The learned tribunal has said it is loan, it is not an advance. And which is there, my lord? Kindly come to page 74, my lord. And 1 year rental comes to around 2.5 crores, my lord, not 1 crore 40 lakhs.
2.5740.
Yes. But then they have given only 1.4 crores. So kindly come to page 74, my lord. Paragraph 13, my lord.
Yes.
Can I place? Save water matters of record and save as would appear therefrom the allegation contained in paragraph 22 and 23 of the statement of the said claim are denied and disputed.
This is your statement.
No, this is the counter statement, my lord.
This is the counter statement.
Yes, my lord. The earlier one at page 9 was my statement of claim, my lord.
Yes, your statement of claim.
Yes, my lord.
This is
Paragraph 22 was there. And this they are replying to paragraph 22 and 23 here, my lord.
This is their counter. Yes. Counter statement.
Yes, my lord.
And counter claim by the respondent number
My
2.
lord. My lord.
Yes. Read it.
Save water matters of record and save as would appear therefrom. The allegations contained in paragraph 22 and 23 of the said claim are denied and disputed. The respondent denies that the respondent number 1 agreed to pay 1 year's rent in advance to the claimant, as well as or at all. With regard to the payment of rupees 1 crore 60 lakhs made by the respondent number 1 to the claimant, as referred to in the said claim, for the sake of brevity and to avoid prolixity, the respondent repeats and reiterates the statement contained here and above. So they have denied that we have not paid rental advance. Then what they have paid is stated in page 61 of this. Page 61, my lord. I have placed this clause when I am referring that loan, my lord. Clause B, my lord, absolutely at the bottom. It is also pertinent to note that the respondent number 1 had provided financial assistance by way of a loan of rupees 1.6 crores. Purchase on tender. So, my lord, I have requested them to pay me 1 year's rental advance.
Yes.
That comes to around 2.5 crores. They did not pay me. They paid me only 1.4 crores. Then they said, Mr. Surana, this is not a rental advance because rental advance would not have been imposed interest. Now they say it is loan. And they have very categorically said it is loan. And they have recovered interest also. And the entire amount has been recovered by them, which I have submitted before Lordship at page 397 to 401. They have claimed 1 crore 60. They have recovered entire amount from me. Now, apart from all this, my lord, the amount was paid to me in the month of June 2008. They could have made refund of loan within 3 years. They did not take any steps for recovery of that loan. They have filed a counterclaim in the month of July 2013. So it is barred by law of limitation. So my humble submission is, my lord, as far as 1.6 crore is concerned, it was not 1.6 crore, it was only 1.4 crores. The 20 lakhs was given to me for opening a letter of credit for making payment to the electricity charges to the board. All relevant documents have been placed before Lordship. The entire amount has been claimed by, has been recovered by them at page 397. Volume 3. Anyway, my lord, these I am pretty sure your lordship has made proper note of it when I am claiming, when I am
Yes,
submitting.
I have taken note of that.
Yes, they have started recovery from, my lord, from August 2009. They have started recovering at the rate of 8,80,000 per month. That is there in 398, page 398, my lord. Lordship will find that 8,80,000 they have recovered every month, and at the end, in page 400, my lord, your lordship will find that they have recovered the entire amount of 1 crore 60 lakhs.
Where are you showing?
At page 400, my lord. Yes, yes, my lord.
398?
Yes.
Which column?
398, my lord. The second column, my lord. 8,80,000 is there, my lord. This is a legible copy, my
Yes,
lord.
8,80,000.
Yes. Now every month they have recovered from August, September,
Principal
October,
amount
November, December.
recovered.
Principal amount recovered they have stated. And then kindly come to page 400, my lord. They have recovered entire 1 crore 60 lakhs.
One 16, yes.
And above that, my lord, you will your lordship will find two columns, two sums, 41 lakh 13,350 and 1 lakh 59,554. This is on account of interest they have claimed. The total comes to 42 lakh 72,904.
No, that is, I think DG said repairing cost.
No, my lord, this is the interest. This is interest.
Interest less TDS on advance given.
Yes, my lord. Yes, my lord. So this 42 lakhs they have claimed also before the learned arbitrator, and the learned arbitrator has turned down the request, has rejected that. So I'm not pressing anything on 42 lakhs because it has not been awarded. What I wanted to humbly submit, and why today's is the date of payment. Probably I did not specify on the last day that it is stated in my statement of claim. These dates have been stated in my statement of claim.
Okay.
So in page 9, my lord. And in page 61, they say it is not an advance, it is a loan. And which has already been recovered, which indicates at page 400, my lord.
Yes.
Now, my lord, this claim they have made before the learned arbitrator on 13th of July 2013.
Beyond the period of limitation.
Beyond the period of limitation. So it should not have allowed. I mean, it should not be considered when they have already recovered the money from me. There is no question of any claim, my lord.
Okay. That's all for the.
Yes. And initially, I have submitted before your lordship. I have placed one judgment which was delivered by Bombay High Court on 1st of March 2013, which was there in AP 700. I have placed before your lordship. In that, my lord, they have filed an affidavit that they have already filed a bank guarantee of 6.5 crores in Calcutta High Court. And I have submitted before the Honorable Judge that it has not been submitted. And I have placed a letter which was issued on 27th of February by the registrar that we have not received any bank guarantee. Now, in the judgment, my lord, it has also been stated if it is found wrong, the necessary consequences will follow. So I have placed on this judgment before your lordship. I'll just place the copy of affidavit which they have filed. This was filed by one Mr.
No,
Virendra Samani, my lord.
You have placed this to show their conduct.
Yes, yes. I have placed this. The copy probably was not filed before your lordship, so I am just placing.
No,
this
you have placed this copy. I have the copy. At the time of argument, you have placed this. Very well. I am again taking it. This may not
have been before the tribunal. I will have to check.
Yes, yes. It was not before the tribunal. At the time of argument, I have also said. Now I am also saying this is in respect of conduct of the respondent.
That's right.
My lord, this is not only conduct, my lord, this is based on the judgments. These judgments are relevant. The first judgment has been placed by respondent number 1 and 4 in their section 34 application, which is not before your lordship at the moment, my lord. It is there. They have this. So these are all relevant, my lord. Number 1. Number 2, Mr. Medora has filed an application in the Bombay High Court for amalgamation of respondent number 2 and 3. There also, there one of the directors, Mr. Rampal Ladda, had filed an affidavit that I have already filed a bank guarantee, which was not there. So what I wanted to humbly submit, both the judgment delivered by Bombay High Court were obtained by practicing fraud. And I have placed before your lordship a judgment of SP Naidu of Supreme Court that such action can be taken by, can be placed before any court, even interlocutory court is at this stage also, my lord. Although the judgment was delivered by Bombay High Court, your lordship has to assess what action can be taken for this misrepresentation or by the suppression or fraudulent action.
Okay. Okay, that's one.
Small thing, my lord, I'll take. When I was making my submissions in respect of those damages for project escalation and other things also,
Yes.
I have not been able to convince my lordship that I am entitled for any loss which I have sustained. My lordship has said, no, you are entitled only for in respect of that agreement or for in respect of that particular property. So I have said my property includes all the 3 buildings. And I have said that the section 33, section 73 of the contract categorically states any loss which I have sustained.
Yes.
My indemnity clause also any loss I have sustained. So my humble submission is, in terms of my clause stated in the agreement, in terms of the statute, I am entitled. And the judgment which I have just now placed before Justice Sapre also said the same thing, my lord. And what I wanted to humbly submit, my lord, that this was a pre-decided by them. They wanted to buy my property. Various documents are there from page 226 to 332 of my volume 2, my lord. All documents are there. Your lordship will find that they have decided to my property at 18 crores. They wanted all details. I have given them all details. They were aware of everything. They cannot say that Mr. Surana has not performed his performance. If I have not been performing, I have not been providing necessary services, they would not have come forward to buy my property. These documents are there. So they wanted to buy this property. They did not make the payment of license fee according to the schedule stated in the agreement, so that I was forced to offer them a lower price. So this was a pre-planned by them.
Okay.
This is the stated.
This is your argument. Yes.
And finally, my lord, I have placed one sheet. I have given one sheet, my lord. Where I have indicated one sheet, I have just project that. So I find that it is disclosed at page 52 of my statement of this disclosure of document also. Your lordship can release that plain piece of paper. It is there. What I just wanted to say that these 2 spaces were not delivered to them. in their agreement did not sublicense this premises, this part of the premises in terms of my agreement with the railway. It was not given.
So what you want? Those documents you want?
No, I don't want that. I have given a plain piece of paper.
Yes, yes.
I find that this is there in the original documents also, my lord, at page 52.
Okay, okay. Regarding block A, block B, block
Yes,
C.
yes, my lord.
This
No,
paper.
not block A, block B, block C. Floor plan, my lord. I have just taken a small piece of paper and I have just marked.
Okay, okay. I understand. Now I understand.
Floor plan was there.
Floor plan already placed before the arbitrator.
Yes, and it is a page 52 in my documents also.
Very good.
And I humbly request, my lord, though I have not been able to convince your lordship that I have suffered loss, your lordship is still of the opinion that I am entitled for loss in this.
I have not passed any opinion on that point.
But of the opinion means, Lord,
You may understand. No, I have not passed any opinion on that point. No, any point I have not passed any opinion yet.
What I could understand from the discussions which I have had with your lordship, that probably I have not been able to convince your lordship. I still reiterate that section 73 and my agreement entitles me to receive any amount of loss which I have sustained because of the breach of contract.
Yes, you are good on that point. Very good.
During reply, I will place further judgments also that your lordship would go only.
Let them finish first.
No, he cannot place further judgments in his reply. That is unheard of in law.
Yes.
Whatever judgments he's placed.
I-
Otherwise, there will be a continuous
Listen.
ping pong battle.
I have placed those judgments. I will highlight those. The judgment was in Calcutta High Court and Supreme Court that the statute has to be read what is there in the statute.
Very good.
I have placed those judgments. I will not be placing.
No, then don't place again.
Order copy. Order book. Order book. Last part again. Okay.
मेरा जजमेंट थोड़ी कभी नहीं होता है.
Today is fixed for argument on behalf of the respondent. Full stop. Mr. Medora, learned counsel, appearing on behalf of the respondent, submits the respondent are in difficulty to argue in this matter. On the contrary, Mr. Surana, Mr. Lakshmipat Surana, in person, submits that he wants to submit some imputes along with the in support of his judgment, in support of his argument. Hearing the parties, Mr. Surana is allowed to submit further argument. Full stop. Next argument on behalf of Mr. Lakshmipat Surana is concluded. Let the matter be listed for argument on behalf of the respondent on
31st minute.
31st. I have said 31st of July 2025, specially marked at 2 p.m.
Instead of unable to submit, will kindly use some other language. Seeking some time.
Now, since the order is there,
I know.
Mr.
Very
Surana has concluded.
Very well.
That's why I want to.
My lord, yesterday your lordship had decided another matter on 31st at 2 p.m. My lord. Yesterday.
Yes, one matter.
31st. Contra. Huh? Landed. Group 1. 31st আছে নাম্বারটা বলো আমায়. Okay, this accusation process.
इसको कर लो. हाँ, 30th.
First কিছু নেই. Instead of 31st, 1st August.
First time not in Calcutta, my lord. So
Okay, then 31st. It will be first matter. This matter, it will first court.
I'm grateful for that.
2 p.m.
Grateful for that.
On the top.
First matter.
On top.
I'm extremely grateful, my lord.
Okay, thank you.